Des, there was a landlord in West London that Landlords Defence had to help out of a bit of a tricky situation. Tell us about it.
Yes, very, very interesting. The gentleman was looking to find out with the new legislation whether he needed an HMO licence for his property. He'd read the general information, he'd followed the council's website, but he had not been able to get a response from them on the phone. He'd called a number of times, he'd sent emails and got no response. The deadline was looming.
And he wasn't sure because it wasn't a normal HMO, was it? It was a specialist occupation of his building.
Yes, it was a specialist occupation because he was helping an organisation. His tenant was an organisation that was orienting refugees who had entered the country and orienting them during the daytime, and this was the home that they lived in at night. So they had 24-hour care person in the property. So it was a little bit different, but no, it's not unusual. This was a house in multiple occupation, a perfect example, because as many people don't understand, a house in multiple occupation occurs at 3 occupants where those 3 occupants are not related and they share facilities. Now, this property was in an area that needed some licensing called additional HMO licensing. Because he hadn't got a response, he engaged with us and we had a meeting and went through his current situation and what was going on, and inadvertently and through his lack of knowledge and lack of finding out that knowledge, because he hadn't consulted with us before entering into letting this tenant in, he found out that he had actually been running an HMO and he'd been doing that for the best part of 12 months.
Without the licence that he needed under this additional HMO licensing scheme.
Exactly.
So he's in big trouble.
Well, he could have been, and we have to be careful because we have to protect him because we have that client relationship. But the most important thing is that his tenant was also in arrears with their rent. So the first thing we did was establish what was needed in order to do the application for the HMO licence. Went through that process, had an inspection of the property, and I guess this inspection must have made the tenant think there was something else happening. Because they were in arrears, they very, very quickly said they were moving out and moved out much sooner than the date they claimed they would move out.
Mm-hmm.
They left some arrears, yes, but the great thing was we would have prepared an application if they were staying, and if they were going, because he'd served the notice to evict them, we would have gone for a temporary exemption notice, and we would have gone to the council, and that would allow us 90 days to either license the property, which could have left risk for him because of the previous, or to return it to a standard residential letting through a letting agent or directly to individuals. And that situation, it sort of disappeared because the tenants had left, the occupants were gone. He was left with some arrears and now the house was empty. So he did some repairs to the damage that they did and now is letting out the property as it should be. But anybody can fall foul of this, and I do believe that because it's been returned and because no enforcement action or no notice has gone, nothing further will happen. Hopefully no retrospective action will happen because he's moved on. But everybody should be very, very aware. Ignorance is not a defence in law. Not at all.
Absolutely not. Now, this was a residential house? 3 or 4 bedrooms, something like that?
Yeah, this was a 3-bedroom house that had been extended and had, I'm trying to remember now from the floor plan. I think it had 4 bedrooms, 4 occupants.
So we're not talking a big place.
No. 4 occupants, a lounge, kitchen, in a general communal area.
And he'd let it to a company.
He'd let it to a company.
So he probably wasn't even aware that it was an HMO and he needed a licence.
I think he was aware of what they were doing, but I don't think he was fully aware of the licensing situation.
Mm-hmm.
And yeah, he should have done something about it. I think he thought there were only 3, but there were actually 4 people there.
Right. So it's very lucky that he called in Landlords Defence and didn't end up in a lot more trouble.
If he hadn't called us and we hadn't taken action with him immediately, I think he was really getting into all sorts of tight water, because he didn't also know what to do about the rent arrears and how to evict them properly.
Now, interesting, you were lucky in that case that the commercial tenant went just of their own volition, but you'd got a strategy there, you mentioned a moment ago. Just explain how that would work. You actually got the council to do something there to help evict them effectively, or you were going to.
We were going to use something called a temporary exemption notice.
What's that? Tell us what that is.
That is when you have a property, and normally the council would come along and find out you've got a property that's running as an HMO. And sometimes this happens where people inadvertently have an HMO. The council believe it's an HMO, and they say you either need to get a licence or you need to return it to a residential property. And normally people do that